Good afternoon, everyone, and welcome to this webinar. Our purpose this afternoon is to discuss the Assisted Outpatient Treatment Program, commonly referred to as Dolores Law. We have reached a critical juncture in the implementation of AOT, as it is referred to. Previously, the program's implementation in any county was really left to the discretion of the Board of Supervisors, required a number of factors to be in place, and required the Board of Supervisors to then approve voluntarily that they wish to move forward with the program. And as a result, the number of counties that actually participated in the program and have been participating has not been very large. However, subsequently, the legislature amended the statute creating AOT through AB 1976. It made a number of changes in the law, but most specifically required counties to either opt into the AOT program or state clear reasons why they were not doing so by 2021. And we know that at least 23 additional counties and probably more have opted into the program through action by their Board of Supervisors. AOT is designed to work with and engage mentally ill individuals who chronically leave treatment and resist medications and treatment. Successful implementation requires strong and close collaboration between the court and the treatment system in your county. This webinar is being offered for judges only. However, we have planned a one-day in-person conference for January 26th. If you please note it on your calendars, and that will be in Sacramento, and will permit each county to send teams to the conference that will include the judge, treatment, the attorneys, and other stakeholders to participate in a more comprehensive training and planning process. Our goal is to make every effort so that implementation of AOT programs or improvements in existing programs are a real success. And I assure you that judges are critical to that process, as you will learn today. I would now like to introduce our presenters for this webinar. Judge Tom Anderson is from Nevada County, where the first AOT program was implemented many years ago, and his leadership has made that program a national model. Brian Stetton is also joining us. He is the policy director for the Treatment Advocacy Center and has played an important role in the successful implementation of this program in many states across the country, and he is a national expert in this area. With that being said, we'll move right to our presentation, starting with Judge Anderson.
All right, thank you, Judge Manley. What I'm going to talk about today is basically an overview with some specifics about how the programs work and how we've been able to make it work in Nevada County. I'm going to touch on four basic areas: a brief history of our implementation, how our court and treatment systems collaborate, the Black Robe effect, discussing how it is real and how much of a difference it does make, and also talk some about interpreting the criteria for Dolores Law under the statute, Welfare and Institutions Code 5346. First of all, let me begin with Dolores Law began in Nevada County. Our hearings began in 2008, and they began because in 2001, a behavioral health patient arrived at the behavioral health office for a scheduled appointment. His family had been calling the department for many months to discuss his increased paranoia, his hallucinations he was having, and his arming himself with multiple firearms. But he really didn't meet any specific criteria for 5150 or anything else at the time, and nothing was done about it. So there was no intervention. He fell through the cracks. And then on that day in 2001, reacting to some hallucinations he was having, he left his beloved little dog in his car, and he grabbed a firearm from underneath the seat, and he went into the office and started shooting. At the end of his rampage, 3 people were dead. Many people were wounded, and the county was simply terrified. Laura Wilcox was one of the victims for whom Dolores Law is named. She was a 19-year-old honor student at Haverford College, volunteering at the behavioral health office because she was on break and knew they needed help from her prior volunteer efforts. In response to her death, her parents demanded the county implement assisted outpatient treatment. The county agreed, but with the provision that they would only do so once separate funding became available. And in about late 2006, 2007, MHSA money was made available to the counties, and our county used that to begin implementation of Dolores Law. In 2008, we began to hear Dolores Law cases, and soon found it to be one of the most rewarding judicial and treatment experiences for those who participated, both from the bench, from the service providers, and the participants. Seeing those individuals with severe mental illness gain stability and independence is an amazing experience, and that we've continued to enjoy. Since its implementation in our county has saved tens of thousands of dollars yearly. We have Dolores Law. We're able to intervene with folks who are suffering from serious mental illness to avoid a forced hospitalization, or they're being placed in jail, or suffering serious injuries or causing injuries. In each of these interventions, each of these participants ultimately saves the excessive costs associated with, as you all are well aware of, associated with trying to hospitalize somebody under 5150, or conservatorships, or keeping them in jail, plus it benefits the community with less emergency room visits, less law enforcement interaction, and provides some solace to families. Which brings us to how the court and our treatment providers cooperate. As the central pillar of the AOT program, like any collaborative court, is between the participating agencies. Here it's a public defender, county council, the court, and behavioral health. Excuse me. The primary connection of all of that is between the court and the treatment provider. It is the key to the success of the program. In Nevada County, our provider for our Dolores Law participants is Turning Point, which operates under a contract with our behavioral health department. So when a Dolores Law referral is made to the county, a mental health professional from Turning Point reaches out and conducts an intervention interview with the participant, with the person referred. An assessment is made as to whether or not they meet criteria and whether a petition will be filed. And however, at the same time, they're offered, as required, they're offered to participate voluntarily in services. And that's one of the biggest benefits of having an active AOT program in your county, is that most of the people, over 50%, accept voluntary services, and they become engaged and find stability based upon that initial outreach, that intervention, and that's priceless. Turning Point provides the 1 in 10 case manager to patient ratio. That means 24/7 availability of contact and supervision of the participants. They provide routine check-ins with the participant. That's multiple times a week at a minimum. In some cases, it's multiple times a day, depending on need. But because of that 1 in 10 ratio, they have the ability to do that. They provide routine check-ins with the participant, and that could be, and they provide med compliance. If necessary, they deliver meds to where the person is staying. If necessary, they wait and observe them taking their meds. And for some individuals, they deliver meds twice a day. But it's focusing on their relationship with the court. The treatment provider submits a status report for every review hearing. And we conduct review hearings probably every 2 or 3 weeks, depending on the need of the individual participant. Sometimes it could be longer if they're doing well and don't need to come to court. Some of them like coming to court, so we do it more often, and some need more supervision, so we bring them weekly. The status reports that the treatment provider provides is basically an outline of what their treatment plan is, how long they've been in the program, and what they've been doing. How have they been participating? Have they met with their doctor? Have they made groups? Are they participating in activities? How's their housing? Are they getting food? Are they getting activities? And also reference problems and successes in their personal lives. Usually it's only a page long, but it provides enough information to help me conduct a dialogue with the person and to assess their status and help, hopefully, to keep them motivated. Now, the court time involved in this is pretty minimal, but it's essential and it's the most important part of the program. I'm thinking some of the times they're only 5 or 10 minutes long to have this chat with the participant. But it's that chat that makes the connection. And in many cases, is the reason for success. Now going back at the status hearings, generally I defer to the professional recommendations of the treatment provider, simply because they're the mental health experts and I'm just a judge. And I'm not a mental health expert. Certainly sitting on the bench, you experience a whole lot of different types of personalities and illnesses, and you deal with it. But nevertheless, when you're coming to individual therapy, we generally defer to the mental health professional. I don't attempt to, substitute my amateur psychoanalysis for the professionals. However, I do ask questions, and I make what I hope are practical suggestions. And most importantly, my questions and suggestions are most often designed to express and support care and concern for the participant, to advocate for resources for the participant, to show support and encouragement. That is to say, to demonstrate caring. And that is the key aspect of all of this. And here is where we engage and create the black robe effect. And there's lots of studies, but it's more practical experience that many of you have already experienced in other courts. But it's real and it makes a big difference. The show of support, of caring, is where we earn the benefits of the black robe effect. By letting the participant know that we care about their participation, about their welfare, about their feelings, and we listen to their self-reporting, and then we respond, often using what's now referred to as motivational interviewing techniques, engaging with the person and supporting them and motivating them. And you've done this before in other courts. Many of you, you've supervised, participated in drug courts or mental health courts, DUI courts, and you get that experience where you thought you processed, they've gone on your calendar, you've met with them in that court, and they've gone through their procedure, their process, and they come up to you at some point later and express their appreciation of what you did for them. You see, maybe you sent them to rehab, you gave them a second chance in some fashion, and maybe you just listened to them. And even though it may have been just another case in your calendar, their connection to you was very real, and it may have changed their life. So in Laura's Law, like the drug courts, that connection is the motivation they need to succeed. They want to please the judge. And in the course of their illness, they've experienced doctors and social workers and attorneys who they felt were just processing them because it was their job. And for many, the last time they saw a judge is the one who sentenced them or authorized their hospitalization. But when they sit in the civil program, Laura's Law, and they experience a judge who cares, that is the game changer. That's what makes this work. It amazes me every court session how often a participant wants to please a judge. And as a result, from them finding acceptance from you, they begin to accept services that they previously had refused to accept. And then they're on the road to stability, to independence, to success, and getting their life back. But to earn the status as a judge comes with a proviso that's probably best stated with a quote that I took from a mental health treatment peer, which is simply, quote, "When you ask someone how they are doing, be prepared to listen, because sometimes we just want to know someone cares." And that kind of sums up how to proceed and how to process cases in a Laura's Law hearing setting. The other thing I wanted to touch on is the Laura's Law criteria. Welfare and Institutions Codes 5346 is pretty straightforward. It sets out the procedure, requirements, and criteria for implementing and conducting Laura's Law or AOT hearings. But as can be anticipated, there are some phrases in there that some may consider vague or not conducive to being inclusive. So as you apply this law to real people, I always remind myself that the purpose of the law is to protect and save people, to help those who are decompensating and otherwise likely to end up forcibly hospitalized, jailed, or worse, to stay out of confinement, get stable and back on their feet. In other words, I remind myself that the goal of this law is to be inclusive and not exclude those in need. The statute was created to intervene before decompensation gets to the point where someone's going to be 5150'd or arrested or get involved in something harmful. And of course, in the process, and this is always necessary, I think, to remind folks, it saves a lot of money for the county, for the families, for the community. The criteria is not as strict as 5150. It's not meant to be. It's meant to be to prevent people from reaching that point where they would be 5150. So in interpreting phrases and criteria, I do so with those thoughts in mind. For a couple of examples, 5346 refers to, used to be the condition had to be the person had to be currently decompensating. That's been changed to substantially decompensating. But I sense some folks already, have an issue with what does that mean substantially. And substantially just simply means to a great extent or generally. And generally deteriorating means they're deteriorating. And they're not going to survive safely unless they get some treatment. What's up? 5346 A3. One of the criteria is that they're likely to relapse. And in trying to determine what likely to relapse means, you can look at their history. So, and that's just as irrelevant as in an LPS hearing or other similar. Likely to relapse can be easily determined from their history, and Then we move on to 5346 A4A, which brings up an issue that's been raised several times over the years when a new attorney comes into the case, which requires that a person within the previous 36 months has been confined primarily because of their mental illness and have been in a mental health unit, hospital, forensic unit, or a local correctional facility. And the issue argued was because our local county jail doesn't have a mental health facility, it doesn't meet criteria. But that's not how the statute actually reads. It's or a local correctional facility. And if they're in there, if they've been jailed because of their mental illness, that meets criteria. Another example is 5346A5, which is if the person continues to fail to engage. Fail to engage does not mean refuse to engage. It simply means that they're not totally participating. The person may be attending groups, maybe attending doctors' meetings, but they're not engaging in a meaningful way. They're failing. It's like they're attending school, but they're not passing the class. So the significance of interpreting these phrases broadly is to support the goal of the statute and provide these services for a target population that has in the past fallen through the cracks. So Dolores Law is the safety net to catch those people so we can prevent them from being 5150'd or being jailed or being constant visitors to the ER, and give the family some solace. And it's the only thing we have to do that. But the remarkable thing is that it works tremendously well. It has a long history. Some other states have had programs a lot longer than we have. And the statistics that support them are so impressive. It's a wonder why everybody hasn't already done it. So we do it to save money, but we mostly do it to save lives and help people get their life back. So that's a brief overview. I could talk about this for a couple hours, but I won't today. I'll get another chance later. Brian?
Yes, okay. I'll take it from here.
Thanks, Tom, and we're going to turn it over to you, Brian.
Very good, and I'm going to share my screen if that's okay, as I've got some slides.
Sure.
Let's see if I can do this smoothly. And just got to go into
success.
Slideshow mode. Yeah, almost there from the beginning. Okay, got it. Hey, everybody. So great to be with you today. I'm Brian Stetton. I'm the policy director for the Treatment Advocacy Center. And, you know, we're a nonprofit that has a mission we've been on for over 20 years now to make AOT a routine practice of every public mental health system in the country, to get past this point where it's a novelty or something that's, you know, being done with some exciting results in a few places. We want to get to where this is a tool in the toolkit, not to be used in every case, but to be used in that subset of cases where it's appropriate, no matter where you happen to live. And obviously, we're extremely excited about the breakthroughs we've had recently in California. And as Judge Manley mentioned, this really is a critical moment because we have so many new counties. I'm sure many of you are representing counties that are just coming online with AOT and preparing to implement the program next year. And so I wanted to use the time I have with you today, just about 15 minutes before we open up to Q&A, to walk through some of the things that I think we as an organization, ATTACK, have really learned as to the keys to successfully implementing this program. Well, what you really want to have in mind when planning what your AOT program is going to look like so that you set yourself up for the greatest opportunity for success. And as I have in my headline here, these are really just a teaser. These are three of many keys to successful AOT implementation that we have identified as an organization. For more detail and more information, you can check out our white paper. If I could just ask Amy to maybe put a link in the chat box. And by the way, let me ask you also to use that chat box or the question and answer function to put any questions that may arise from my presentation or Judge Anderson's that will then be able to look through when we get to that segment of the hour. But this Whitepaper was really developed not just by us, really in conjunction with a really extraordinary team of AOT implementers, people who have operated successful programs all over the country, kind of sharing their knowledge as to from the mistakes that were made very often in the initial phases, as to what exactly it takes to do this right. And so we walk through lots of kind of building blocks to how to set a program up, and then tips for how to be successful over time. And I'm just going to pull out a few of them that I think are particularly relevant in California, just based on what we have seen some of the programs do differently in your state. The first thing I want to really address, and I think we just need as a little background here, is this really important need to make step-down AOT the norm. And so when we say step down, just to distinguish that from what has become the more common practice in California of step-up AOT, when we say step up, we mean the idea of stepping somebody up to a more restrictive level of care than they are currently under. And so this is what's happening in most California counties that are doing AOT now, that people are coming into AOT programs from the community. These are folks who are identified as experiencing psychiatric crisis, may have histories of hospitalization or arrest, but at this particular moment, they may have been 5150 and found not to meet inpatient criteria, or maybe they don't even meet 5150 criteria, but we all see where this person is headed. And so we're using the AOT law in many places to put a person into an AOT program, hopefully to help them to avert the need to be hospitalized or arrested in the near future. The alternative to that, the more common thing you see elsewhere, is step down AOT, which is that's about stepping somebody down to a less restrictive level of care than they are under now. In other words, people who are currently hospitalized, who are ready for hospital discharge precisely because they've been stabilized in the hospital, are no longer such a danger to themselves or others that they need to remain confined. They have some tenuous grasp on stability, and hopefully, although not necessarily, they are recognizing at this moment that they have a particular need for treatment. And so where we do step down AOT, we are simply trying to smooth a person's return to the community, give them kind of a soft landing back to a state of full independence with this AOT order in place to keep some restrictions in their life, but less than what they had obviously been experiencing when their very freedom itself was restricted. So our strong recommendation is to make step down AOT the norm. Both types of AOT really have their place in a well-functioning program, but there are some real significant advantages to doing step down AOT that really, I think, have to be understood. First of all, it usually means starting the person in a better frame of mind, right? When you have somebody who is coming into the program with an understanding that treatment is probably in their best interest, and they are happy to be leaving the hospital and are in no rush to get back there, you're taking your first step with the right foot. And that's going to lead to improved outcomes because you're not trying to win the person over from day one. It's also much easier to identify the people who you are going to want to make subject to AOT, that is, people within your county who meet the legal criteria. You don't have to go out and find them. You don't have to hunt for them in the community or wait for people to call you about somebody in their family who's in crisis. They're basically coming to you when you are using this as a hospital discharge planning mechanism. These are people who are coming into the hospital who have been hospitalized multiple times recently, which is why they meet criteria. And when you're identifying folks that way, it's going to lead you to a larger program, and just having a larger portion of the people who in your county who meet criteria under AOT, because you haven't had to do the work to go out and figure out where they are. And of course, it also eliminates the challenges that are associated with step up AOT, where you have to, find the person. You may have somebody who's in the community and you've got to serve them with papers, and you've got to figure out how the required evaluation is going to be performed on that person who doesn't want to submit to it. When you have somebody who's in the hospital and you're starting this preparation period while they're under hospital care so that they can leave the hospital with this court order in place, all those challenges are solved for you. And so I don't think it's surprising that nationally, this is typically how most AOT programs generally operate. These step-down cases are the bread and butter. of AOT programs, and that just hasn't been the case in California. And I think one of the main reasons for that we've tried to address in this really exciting new legislation that was just passed in the last session, will go into effect on January 1st. With SB 507, we removed what I think was one of the greatest barriers to doing step-down AOT in California, which is that under the criteria as they existed before, it was required in every case that you find that the person's condition is substantially deteriorating. So you'd have to have somebody in court, if this were interpreted very narrowly and rigidly, in a state of deterioration in order to just be eligible for AOT. And it's very hard to make that claim about somebody who has been stabilized through hospital care, is coming out of the hospital specifically because they are not at that moment substantially deteriorating. And so step-down AOT cases could easily be found to not meet criteria under that old standard. We now have made that substantially deteriorating an alternate criterion, so that now you can base it on a finding that the person is either unlikely to survive safely in the community without supervision and is substantially deteriorating. That's your step up AOT. Or alternatively, the person needs AOT to prevent a relapse or deterioration likely to result in grave disability or serious harm to the person or others. So here you're not looking at the person's current condition so much as what their history tells you about what is likely to happen to them if left to their own devices. And I'm optimistic and hopeful that this is going to lead to a really new approach across the state, how we funnel people into this program. So let's now talk about the AOT court order a little bit, which I call a strange bird because it's just so different from every other court order that we're familiar with in other legal contexts. And this was going to lead me to my keys 2 and 3 that I want to address today. You know, when we normally think of a court order and why it's effective, why it has an impact on people's behavior, it's generally because people are afraid of the consequences of what's going to happen if they don't follow it. There are teeth attached to court orders generally. That is, you are going to be in trouble if you don't do what the judge has ordered. You're going to be generally held in contempt of court, which could lead to imprisonment or jailing or fines piling up on you. That's the last thing we would ever want to do with this population. So quite rightly, the law takes that contempt of court possibility right off the table. We have specific language in there that says you're not going to hold someone in contempt of court for violating this particular type of order. And we take away other remedies you might naturally associate with this court order in order to give it legal effect. We are not going to allow violation of the court order itself to be grounds for inpatient commitment. That is, we're not going to inpatient commit somebody who has not been found to meet the ordinary criteria for it. Wouldn't be constitutional. Nor are we going to allow a violation of an AOT order to be the grounds for forcibly administering medication to somebody. That is, restraining them and medicating them for not taking the meds as they've been court ordered to do. That's something that takes place as a last resort, sometimes in a hospital setting. It's not going to be a part of an AOT program. We have specific prohibitions against all those remedies in the law. And so, you know, sometimes I lose judges at this point in the presentation. They sort of ask, well, what's the point? This is kind of a paper tiger. And it's a fair question to ask. And I have a couple of responses to it. And the first is one that Judge Anderson spoke of a little bit already, what we are trying to accomplish through this admittedly fairly toothless court order. There is this magical thing we call the black robe effect. And it's simply the notion that, you know, that a judge's words being told by a judge, here's something that we need you to do, is just fundamentally different than being told by your doctor or your mom for the millionth time that, you know, we need you to take medication. It gets the person's attention, the solemnity of the court process. It's not going to be a magical effect that sustains itself. Ultimately, you know, other challenges are going to enter the person's life, and we're going to have to rely on something more than this black robe effect, i.e. having the person have a sense that the judge is on their side. But it's certainly a starting point for getting a person to take seriously the need to stay engaged with treatment. And we reinforce this through the status checks that take place during the period of the court order, where the person's coming in and seeing the judge. And I think it's also really important to keep in mind that this black robe effect works on the treatment system too. AOT at the end of the day is a mutual commitment. It's about committing the treatment system to the person as much as it is the reverse. And so there's real power in this. And we don't want to deny it to anyone who we place under AOT. And that's why what leads me to this second key I want to share with you today, the importance of giving every participant in your AOT program the benefit of that judicial oversight. These step-down participants are more often than not going to be willing to enter voluntary settlement agreements as the law allows. A specific provision for that says you don't have to do an adversarial hearing if in essence the person is stipulating that they meet the criteria and is willing to voluntarily settle the case. But to its credit, the statute also makes clear that this settlement agreement is not something that happens extrajudicially. It's not something we don't bother the judge with. On the contrary, it requires court approval, and the statute says the settlement agreement shall have the same force and effect as an AOT court order. And so those terms of the settlement should absolutely require those same check-ins with the judge that a person would have if they were actually under a formal court order. We want to make sure everyone that we call an AOT participant is getting this benefit, because this is the secret sauce of this entire approach. That's not the way many California counties have proceeded with AOT. I'm sometimes distressed to see programs that label people as AOT participants when in fact they have zero court involvement and interaction with the judge, because the matter has been settled without actually getting to the point of filing a petition. And people are participating in the program through just private agreements with their county mental health department. And I understand why programs have gone in this direction. I think it's also the result of some language I wish was worded a little bit differently in the law. One of the criteria is that the person has been offered an opportunity to participate in a treatment plan, including all of the services described in 5348, and the person continues to fail to engage in treatment. And there's a common sense reading of that, I understand, that would lead you to say, well, we can't file the petition unless we've made this offer to this person to do the program voluntarily. And if they say yes, we're kind of required to give them one chance to participate that way. But I would ask you to think about whether this language really means that you can't go to court on the first pass through AOT, so long as in that person's history, and remember the criteria require a history of lack of compliance with treatment. So long as that history includes a lack of compliance with treatment that is as good as what would be offered under AOT, that includes all those elements that are listed in 5348. And by the way, 5348 has a provision that says that you've got to make all these services available to voluntary folks as well as people under AOT. If you've already done that prior to even suggesting AOT to the person, then you've got a person who has been offered an opportunity to participate and they failed to engage in it. You don't have to take another pass before you can go straight to a court order. And that's how I would encourage that provision to be interpreted. One quick last point I'd like to make before I turn it to Judge Manley to talk a little bit about the opportunity to use AOT with people who are incompetent to stand trial under some new legislation we have. I would also just like to point out that another point of the AOT court order, and aside from this black robe effect, is to facilitate this proactive response to non-adherence with treatment. I hope I've made clear that there's not ever going to be any punishment of the person attached to non-adhering with treatment, but that shouldn't be confused with the idea that there's a lack of consequence. There has to be something that happens if the court order is violated. And the language is really very clear and very strong in the law as to exactly what that is. And my third key that I would ask everyone to keep in mind in planning your AOT program is to make use of this opportunity to bring somebody in for a short-term hold for evaluation a little bit sooner than would otherwise be available. Whereas if you have someone not under AOT and you're working with them and they've disengaged from treatment and you see where it's going because you've seen this movie before, you typically have to wait for them to do something to demonstrate their dangerousness to themselves or others, to act out in some dramatic way that may actually now have them hurting themselves or someone else, or have them in the clutches of the criminal justice system. The beauty of AOT is we don't have to do that. We can be proactive and respond to the non-adherence itself under certain conditions. And in the interest of time, I won't walk through the specific language here as I had hoped to, because we're a few minutes behind, but I will share this slide and I ask you to please take a look at this language. There is this opportunity to say, hey, we've made good faith efforts to get this person to engage with treatment. I'm worried about this person. I don't know what their condition is. And I do know that they're not engaging with the treatment that's been court ordered. And so the law allows this person to be brought in on a 5150 without the same sort of evidence of dangerousness that you would ordinarily wait for. And with that, I would just like to close by reminding you that we at TAC are here to help you in all kinds of ways. We hope very much that you will attend the live training, in which we'll go into many more keys to successful AOT implementation. We have many resources on the web. I'll ask Amy again to put a link to access the AOT portion of our website. And we also hope you will use that to contact us for technical assistance, which we provide to programs all over the country. We'd love to have the opportunity to work with you step by step in getting your program off the ground. And with that, I would like to just again turn it to Judge Manley to speak about the exciting new opportunity to rescue people from the clutches of the criminal justice system through AOT.
Thank you. All right. So what I wanted to close this webinar with in terms of what we need to be conscious of is a major change in legislation relating to individuals who have been found incompetent to stand trial who are misdemeanors. Under SB 317, which was the bill, and this law will go into effect January 1st, jails may no longer be used to restore or hold defendants charged with a misdemeanor and found IST. Within 30 days of finding an individual incompetent who's charged with a misdemeanor, they must be released into the community for treatment unless the charges are dismissed by the judge. And one of the options for treatment in the place the defendant, to place the defendant in, is an AOT program. And if the defendant is accepted into the program, the charges are to be dismissed pursuant to section 1385 in the interest of justice. My reading of this is consistent with Brian's presentation that these individuals should be monitored in court if you're going to use AOT and not simply dismiss the charges, because that will be the end of the AOT program. I think the intention was that AOT be an alternative and that the full opportunities under AOT be made available to these individuals, to realizing that we're not going to be able to restore competency in such a short period of time for many individuals. However, the other options are mental health diversion, which is a one-year program that we know of already, or refer the defendant to the county conservatorship investigator, or simply an outright dismissal of the charges that the defendant has been found incompetent to stand trial on. So this will provide a new target population for AOT, and hopefully we will take advantage of that in the future after January 1st. Again, before we open to questions, I just want to remind you to please put down in your calendars January 26th, where we hopefully will have a one-day in-person program to present, in which we will go into much greater detail on all the elements of AOT. But now I'd like to open it up for questions for our experts here.
Amy, would you like?
Can you help us with that?
For the first question is, I work for Kings View, and we've partnered with Shasta County Mental Health to provide AOT services in Shasta County. What would you recommend as the best way to get to know and connect with our local judges?
That's a question for judges.
Go directly to the presiding judge.
Yep.
Because this is a requirement of the court to participate. I mean, this is a calendar that we have to hear. It's no longer voluntary. The judge can just simply, the court can ignore it. So my suggestion is always go directly to the presiding judge and get the judge involved as soon as possible. I know in my county, you know, we have almost bi-weekly meetings with all of the stakeholders set up to put the program into effect. But that it depends on the presiding judge making the assignment and getting the judge involved who will work with you in the program.
And at the very least, the judges generally have a meeting with each other about running the court about once a month at least, and just get on that calendar so you can explain to them what your role is and what you're going to do and how you're going to help them and how they can help you, and make it personal.
Yeah. I'll just add to that. It's maybe a little beyond the scope of your question, but I just think it's very important that the ask of that presiding judge be that one judge be appointed to handle this docket. The cases not just be kind of randomly assigned, and that it be someone who has an affinity for this population and some skill in relating to people with mental illness and making people feel more comfortable than they might otherwise be in a courtroom because they have a sense that the judge is their champion and friend.
Agreed.
Agreed.
Carolyn Phillips asks, I have a client who is perfect for the program. How do I get started? I think the first answer is be sure your county is implementing AOT. And then, most counties have advertised a way to make a referral. Is that correct? I believe so.
And usually,
I would hope so. I know my county, we have gone to great efforts to make the public aware of the availability of the program.
And usually it's just as simple as making a call to behavioral health and telling them that you want to make a referral.
Does Judge Anderson have participants appear on his calendar if they've accepted or on if they are voluntary, or do you just see those where a petition is filed?
Currently, where a petition is filed, but they stipulate to the order, then we treat that as an order, whether it's been by adversarial hearing or by acceptance, by stipulation, and we still process them the same, having them come before the court on a regular basis. Those who have met at the initial intervention and have accepted and successfully participated in voluntary treatment, they don't come to court currently.
Yeah, I think it's important to everyone understand that there are really two types of voluntary settlement agreements under D. The type that doesn't have any involvement with the judge, that happens before a petition is filed. From the point of view of the Treatment Advocacy Center, that's not AOT.
Right.
Whatever you want to call it, it's not. There is no judicial engagement. It's not giving folks the benefit of being part of a court process. It's not AOT. And as I argued in my presentation, I do think that with lots of those individuals, there is the opportunity to go straight to the petition based on what has happened to them before they were even considered for AOT, if they had an opportunity to participate in treatment that was the functional equivalent of what an AOT program would be.
Right.
What reasons do participants most commonly articulate if they are opposed to participation? How do judges address their concerns and hesitation?
I guess I'll jump in on that. Most often it's simply, I'm not ill. I don't need a therapist. I don't need meds. I'm fine. You're wrong for thinking I'm crazy. And that allows us to use the word anosognosia, which is the denial of your illness. But the reality of that is they're not there because everything is going well in their life. So my response to them usually is, let's look at the situation you're currently living in. You don't have a place to live. You're not eating regularly. You're unsafe. You're not happy. And we can help you with those things. So give us a chance to work with you and help you get a place to live and help you get stable in your life, and let's go from there. And that's the part where the black robe effect really comes into play, because if they agree, if they accept that and get engaged at any level, then we can gradually ratchet up the services we provide and ratchet up their treatment. But our goal at the outset is just to get them to engage at any level. And part of that is accepting them as they present themselves, but also being honest with them as you're discussing their situation with them, so that you're on a level playing field and they ultimately trust you, because they know what their life is like. They're just used to wanting to avoid getting into the system.
Yeah. And I'll just add to that you don't really need to get a person to the point where they recognize they have the illness that they are unable to see. Many folks' baseline is such that they're just not going to get there. But there is almost always an opportunity to have people come to see that their lives are a whole lot better when they're engaged with treatment, even if they're not putting it all together, to make them realize that they had that illness after all. That being able to avoid the hospital and avoid jail gives them a higher quality of life and lets them move towards achieving their life goals in a way that they hadn't before they were engaged. And that's the point you're trying to get someone to, and that can take some time.
I agree with Judge Anderson. I often ask people, well, what would you like? What are you willing to do? Well, where can we start here? That's something different than what you've been doing before. What will you meet with someone? Will you at least talk, and then go from there and have a very low bar, and not, I did that this morning, you just not expect someone to simply immediately do all these things you want them to do that they really don't want to do at all, and try and meet them where they are.
Are any counties in California doing what Brian is advocating for? Has there been thought to amending the statute to make more explicit it is allowable / desirable?
So I assume that question is referring specifically to my suggestion of, the opportunity to go straight to the court order without the actual offer of, do you want to do the quote unquote AOT program voluntarily?
Yes.
And yeah. So I don't know. I mean, if anybody was doing it, it would probably be Nevada County. And it sounds like from what Judge Anderson has already said that there is still that offer made to at least most people. Is that done universally, Judge Anderson?
Well, because at the initial outreach, if the person is very agreeable to services and follows through with that agreement, they don't meet criteria anyway. So that's a little over 50% of the outreach of the intervention that occurs. And it's the other half that generally meet criteria and for which a petition is filed, even if they say they're going to accept services, sort of.
Okay, so that does sound like you are doing then what I was recommending, because you're looking at the person's history before AOT was even in the picture, right?
Right.
They have a history of non-adherence. And if you have somebody that has that thorough history of non-adherence, and the treatment they've failed to adhere to was, met all the requirements of the AOT statute, it had all that good stuff in it.
Right.
And you don't have to offer them an opportunity to join the program without going to court.
But it's dependent upon the mental health expert who does the assessment to being on the same page.
Mm-hmm.
We're fortunate here. We have a great team that does that. But if we didn't, it would be a problem. And that's why the court and the providers really have to sit down and have meetings and really understand that they're on the same page.
Right. And
my understanding,
go ahead.
My understanding is that Nevada County has a little over 50% of their AOT participants on a court order.
No, all of our participants are on a court order. Over 50% of the people that are interviewed based on a referral accept voluntary treatment before a petition is even filed. And so by doing so, they don't meet criteria.
The folks who go under a court order post petition, after the petition's filed, that voluntary settlement agreement is effectively a court order because
it is definitely a court order. I mean, yeah. It says so. It is an order.
I guess I'm thinking about all the other counties that consider people who you mentioned interact and then are voluntary, but they call those people AOT participants. They were referred.
We call them, they're ACT participants, assertive community treatment.
Right.
They're not AOT. But they wouldn't have been seen in the first place unless there was an AOT in place and that referral was made.
Right. So have any counties used AOT as a step down for LPS conservatees?
We are just going to have a meeting to try to institute that. We haven't started it yet here.
We haven't, but I think it's a great idea.
Yeah.
Too.
Does the presiding judge have to be from a civil court?
No, the presiding judge is over all divisions of the court.
But I think the question may be asking about the judge who hears the AOT case rather than.
No.
Yeah.
No, it's not the presiding judge. The presiding judge makes assignments and determines, and I think the point is that was made earlier is really critical, is to ask the presiding judge to find a judge who understands how to work with these individuals or is willing to learn, because that's where I think the programs can really go wrong, is if you simply make it as an assignment that turns over again and again and again, and there's different judges who may not have the interest in the program or trying to help people. So it's very similar to the challenges we have in collaborative courts. So that was my reference to the presiding judge. It's just simply that the presiding judge makes the assignments or determines what calendars are heard and who hears them.
Yeah, and the assigned judge obviously has to be one with jurisdiction over civil commitment matter.
Right. I think we're almost out of time.
Oh, right.
We are.
All right. Well, thank you all very much. And again, I urge you, if you have an interest, please let your presiding judge know. And I hope you do. And then I most certainly hope you attend our conference in January, where we will be able to go over all the detail, which is really complicated. And Brian can expand on his presentation, which I think will really be helpful for everyone. So with that said, anything else? Thank you very much, and look forward to seeing you again in January.
Thank you all so much.
Thank you all.
And I thank my panelists.